Okay, in this video I'm going to take a look at my Twitter feed. I take a look from time to time at my Twitter feed, and I have a list of accounts that I monitor, and mainly to do with law and business. So I try to learn stuff and see what's happening and what developments there might have been, new cases and so on and so forth. And then I share that with the people who watch my YouTube videos. So that's what this is all about. It's very straightforward. And as I say, I take a look at my Twitter feed and I have a particular list. I have particular accounts on it, all to do with law and WRC cases and a bit of business as well, although the business tweets that I come across are very salesy rather than educational, so of no great interest in those. But the legal ones I find useful, and as I say, I share them then on my YouTube channel. So we'll take a look now and see what's happening. Today, incidentally, is Saturday the 13th of June 2020. So let's have a look. There's a good bit of chat there on Twitter about the return to work after the COVID-19 closed down, as it were, lockdown, and now obviously there's a return to work protocol. So the whole question of health and safety in the workplace and what the employer's obligation is, what the employee's obligation is, the various steps being taken by both is something that's exercising the minds and the keyboards of many of the people that I follow on Twitter, especially solicitors who will be dealing with employment law. There's an interesting tweet there from the Bar Council of Ireland, Bar of Ireland, about the late Justice Adrian Hardiman and his article or his essay on how Joyce took on the law. Apparently, I haven't read Ulysses myself, but the number of legal characters in Ulysses is rarely commented on. But there are at least 11 judges, 13 barristers, 11 named solicitors, and more unnamed, 2 taxing masters, a coroner and his clerk, a cost accountant, a master in chancery, and a struck-off solicitor. Most are real-life contemporaries of Joyce. So that's an interesting essay. It's the Bar Council of Ireland, and I think it is published, some sort of a book published, or the essay itself is published perhaps in the, let me just check here, Joyce in Court, James Joyce and the Law, Adrian Hardiman, and members can access the book. There's a book apparently written by the late Adrian Hardiman, Legal History, and so on and so forth. So that might be worth having a look at if you're interested in that sort of thing. There's a lot of talk there as well about the difficulty that parents have had with young children and homeschooling, and basically the type of anxiety and stress and pressure that they are under and have been under with 3 months of remote learning. And it is a serious difficulty for parents. It's a difficulty for the government as well, obviously, because they have to try to strike a balance between letting children and teachers, obviously, and school principals and staff, etc., return to schools in an environment which may have a different set of parameters, health and safety parameters, operating than in general society. In other words, if there is no 1 metre or 2 metre social distancing, and that would be very difficult obviously for children, then you are going to have employees, including teachers obviously, and the trade unions are obviously all over this, operating in a different work environment compared to the rest of the population. So that's kind of problematic. But clearly, parents being at home all the time and not being able to return to work, trying to homeschool, remote learning, Zoom calls and all this sort of thing is causing a huge amount of anxiety as well. Yeah, see the RTE reporter Orla O'Donnell tweeting that it's not good enough for children to be in school 1 day a week. It's detrimental to their mental health and social development and unworkable for parents, and we need to sort this out as a society. That's fair comment. Richard Grogan, solicitor, then is saying that the idea of children being back one day a week will result in massive job losses for parents. The knock-on effect, obviously, is job losses for parents and the difficulty with parents attending work in the normal way if they are trying to look after kids who are only attending school for 1 or 2 days a week. That's going to be a serious problem. There's an interesting article there by William Fry solicitors about the difficulty of dealing with a confirmed case of the virus in the workplace, how much information and what information should be shared with employees. Obviously there's a balance to be struck there from a data privacy protection perspective and health and safety perspective, and other employees' entitlement to know as well if they are being exposed. I suppose it's a very, very difficult balancing act to be struck, and this COVID-19 pandemic has set up a huge number of conflicts of rights, conflicts of my right to go to work, for example, or your right to go to work, and somebody else's right to be protected and safe from the spread of the pandemic. So it's a real problem. But as I say, William Fry's article there, it's worth a look if you're interested in this area. Data protection concerns and the disclosure of information about an employee in the workplace with COVID-19, if that is the case. Obviously there's a duty of care to all employees, the one with the COVID-19 and the other employees in the workplace, and then obviously all employees have data privacy, data protection rights. So that's the difficulty in striking a balance. There's an interesting case there as well from William Fry as well. Obviously it's quite a good website. They do some regular blogging, and obviously I keep an eye on what they're writing about and so on. This one is about the evidential difficulties for lenders in obtaining summary judgment against debtors. This particular case, I just had a look at it this morning, is about a bank or a lender, perhaps another lender, some sort of an outfit, buying the loan of a bank. And when it came then to moving for getting a summary judgment against the debtors, the difficulty was the evidence and the affidavit that was to be sworn, because the person who would be swearing the affidavit may not necessarily have had dealt with the original borrowers and so on. So there's a hearsay rule, and this particular case, the lender or the bank, the institution, the company that was trying to get the summary judgment against the debtors actually failed, and the High Court held that the case fell foul of the hearsay rule, because essentially the affidavit that they were able to put before the court by way of evidence wasn't sufficient, because it didn't swear to facts that the deponent actually knew of. There was hearsay involved. There's a good few tweets there now as well about redundancies and layoffs, but redundancies in particular. Obviously the whole COVID-19 situation is kind of coming to an end, and people are returning to work, and obviously the COVID subsidy payments and the COVID-19 unemployment benefit payments, or whatever you call them, the €350 are going to come to a close, going to come to a halt. Employees then will either have to go back to work, or perhaps companies, employers are going to be in difficulty and have to make redundancies, and that is something that's coming up now all the time. I've been very, very busy in the last fortnight or so, indeed in the last week, with the progressive return to work of many employees and redundancies, settlement agreements, selection for redundancy, sham redundancies and so on. But quite frankly, at the moment, with the COVID-19 situation, sham redundancy is a difficult argument to make. You may be unfairly selected for redundancy, but proving it was a sham redundancy is going to be difficult, particularly in the current climate, because let's face it, the employer has a fair degree of protection by way of the COVID-19 thing, and I suppose there is a possibility that some employers are taking advantage of it to weed out or carry out redundancies that they might be challenged on otherwise, but in this particular situation they probably feel confident enough that if they end up at the WRC in 6 months' time trying to justify a redundancy, all they have to do is say COVID-19, and they are going to be in a strong position, I would say, to resist any claim that the redundancy was actually an unfair dismissal dressed up as a redundancy. There's a tweet there about a social care worker granted a temporary injunction halting disciplinary process. So didn't really look into that too closely. It's a social care manager has been granted a temporary injunction against his employer by the High Court, halting what he claims is a flawed disciplinary process. That's a High Court application. He was successful, and where it goes from here, I do not know. That story is in the Irish Examiner. Another case there about constructive dismissal, and I only glanced at it, and I hope I'm not mixing up this case with another one, but in this particular case an employee was racially and perhaps sexually abused by way of some WhatsApp messages or something of that nature. Those pornographic, racial and sexual messages circulated anyway by a manager in a vehicle hire company, and this employee then, who felt to be, or he was the victim of it, or she was the victim of it, I don't know whether it was a man or a woman, they then resigned. And they resigned and brought a claim for constructive dismissal. But I think they lost the case for constructive dismissal because they didn't give the company the opportunity to put right what they say was wrong and caused their resignation. In other words, they didn't exhaust the internal complaints or grievance procedure first, and they didn't give the employer the opportunity to see how virtuous they'd be and how committed they'd be to rooting out the racial and sexual and pornographic material and that sort of stuff. And I think, in fact, the employer in that particular situation had sacked the manager or had taken action. So the problem then, obviously, for the employee who resigns and brings the claim for constructive dismissal is that the employer is going to turn around and say, look, we acted on this, we took action, we were a reasonable employer. And if the employer can say that they are a reasonable employer and that is grounded in evidence and in facts, having carried out an investigation and having taken action, then the employee may well not be justified in resigning and claiming that they were discriminated against or that they had to leave and had no choice but to leave, because the employer, as I say, did take action. And that's all an employer can do: act reasonably and take action when something is brought to their attention. There's another tweet there from William Fry about a case, a WRC case, where the former general manager of a video game company was awarded compensation of almost €100,000 in respect of a gender pay equality claim. So that is a fairly hairy award, 100 grand. Don't know the details of it. It's on William Fry's website, but obviously the likes of pay equality and gender pay equality and discrimination, etc., the WRC adjudicator has a fair degree of discretion as to how much to award if the employee is successful. So employers need to be very, very careful that they avoid any type of discrimination or any type of behaviour that even appears to be discriminatory. There's another interesting tweet there about a Topaz employee, the Topaz filling station outfit. Topaz employee was injured while kneeling during a stock take. So he or she had to kneel down to do a stock take and suffered an injury, I think, to his or her knee and or leg anyway, and was awarded 40,000 general damages. Now you might be wondering or scratching your head as to how Topaz, or indeed any employer, could be held negligent and held liable in circumstances where an employee kneels down and injures themselves and then brings a claim against the employer for a personal injury. Obviously, the judge in this particular case decided that, I think, wherever the stock was located that the employee was trying to count, it was located in a way or in a place, in a situation that might have given rise to the possibility of an injury like this. In other words, it was foreseeable to a certain extent, I guess. That's what I am guessing anyway, but as I say, the bottom line is it was €40,000 ready money, general damages for Topaz employee. Presumably there was special damages as well. Then there's legal costs. So that's an expensive one now for Topaz to be dealing with, and it's not one that you'd expect. Finally, there's a tweet there from Holmes O'Malley Sexton about the potential misuse of inhibitions and cautions with the primary aim of disturbing the sale of well-charged properties by judgment mortgagors. I've written about this myself. You'll have a look at it if you like, if you're interested in it, on my website businessandlegal.ie, where I go through a High Court case which basically involved, I think it was a County Offaly family, and there was inhibitions, I think, registered on Property Registration Authority folios with the view to frustrating the lender's desire to sell the property on foot of judgment mortgage. The High Court in that case, and this is the same case, set aside the inhibitions and cautions, or whatever they were. They're registered on the folios anyway of the PRA, and the reason that they were set aside was because the High Court decided that the only reason they were taken out and registered was to frustrate the lenders, frustrate the mortgagors. So I hope you find this video useful. That's a look anyway this week. Today is 13th of June, Saturday the 13th of June, and that's a look at my Twitter feed. As I say, from time to time I have a look at my Twitter feed and some legal stuff that comes up, and Twitter's useful enough in that way from a research point of view. I know it can be an absolute sewer at the best of times, but if you actually use it as a research tool, it's useful, and you can set up lists, and you can have a stream every week of relevant tweets coming into your list. And therefore I regularly, every day or every second day, and certainly every week, will check my list and check what's happening by launching down through the list of my Twitter feed. And as I say, very specific, very, very targeted practices, and quite frankly a lot of top legal firms I would be following to see, because they obviously have bigger research departments than I have and so on. But if they do some of the heavy lifting, then I can go off then and have a look and maybe put my own spin on a particular High Court case or a particular new development in the WRC or whatever. Anyway, I hope you enjoyed the video, and I hope you find it useful, of some assistance, and you may be interested in subscribing to my YouTube channel. If you find this one useful, though, give it a thumbs up down below. Thanks for your time.